listen closely, I hear my ancestors chant. Tell our stories, redefine a past that was written for us before. Add a chapter, it's time to write a little more. Recast the future, it's time to let our story soar. This is my mana, my spirit, my soul. This is me. This is mana, this is me. When did a textbook determine what makes me who I am? Pages that say nothing of the blood that was shed, the stolen resources and land. But there is still so much that we have yet to learn, hidden in the archives that they couldn't burn. It is rooted within us, look closely and you will see, you will see. So tell your stories, redefine a past that was written for us before. Add a chapter, it's time to write a little more. Recast the future, it's time to let our story soar. This is my mana, my spirit, my soul. This is me. This is mana, this is me. This is mana. She spoke to the ocean and she sang with the trees. She can be heard in the quiet whisper of the breeze. She is everything I aspire to be. She is mana, she lives in me.
Hello, everyone. Hello, hello, hello. Thank you for coming in, and I kindly request everyone to settle down a bit because we start right about now. So let's begin the event, and I'm inviting my colleague Nicole to give some welcome remarks.
Thanks, Aditi. So I hope everyone's had some time or finds the time to sit down and take this all in and process this massive win. It definitely feels like a whirlwind moment even after doing this for over 6 years. And there's so much to say, and I'm very excited to have everyone join us today, both in person and online, all 1,000 of us. Because as much as this is a rapid reaction event, it's also a celebration of our landmark global victory yesterday. So I want to thank everyone who made this event possible, and on such short notice, the Vanuatu government, the Embassy of Colombia, the Embassy of Costa Rica, the Alliance of Small Island States, the Pacific Community, the UN Human Rights Office of the High Commissioner, the Center for International Environmental Law, and Luis from Carlton for our venue, and of course, the powerful youth-led movement at the heart of the case, the Pacific Island Students Fighting Climate Change, and the World's Youth for Climate Justice for putting together this important event. And special thanks to our team at CL, Joey, Seb, Kat, the team at PISFCC, Sonia, and of course the team at WICJ, there's Aditi, Jule, Quint, Mariana, Jose, Ali, Lolita. These people literally pulled all-nighters who were able to dive into the biggest case that the ICJ has dealt with so far. And as the court said, the questions put to it represent more than a legal problem. They concern an existential problem of planetary proportion. So this moment is really a testament of the power of the people, the youth and global majority communities who have made the world listen. So now I'll pass it on to our moderator for this event, who honestly needs no introduction, a good friend, Vishal Prasad, the director of the Pacific Island Students Fighting Climate Change, that started and led this journey to the world's highest court.
Thank you, everyone, and thanks, Nicole. It is truly great to have you all join us for this session. And I will be moderating this session. It's great to have an excellent lineup of panelists and speakers today. We're very excited with everyone in the room. And I wanted to start with just setting or grounding us today by talking about or explaining what motivated our campaign or young people to take climate change to the world's highest court. Simply put, this was an innate duty of care that was shouldered by Pacific Island people. What began as a simple assignment question in their university classes sparked the start of a global campaign to seek definitive clarity from the International Court of Justice on the obligations of states regarding climate change and the consequences for not abiding by those obligations, with special consideration of small island developing states and present and future generations. In essence, the campaign to take the world's biggest problem to the world's highest court. For its founding members, this campaign was more than just precedent and procedure. It was about the weight of belonging to places whose existence hangs in the balance. The duty of carrying the voices of one's own community with the understanding that the ocean and land are not resources to be consumed, but ancestors to be honored. For those who joined the movement, the campaign became a vessel for something deeply personal. The refusal to accept that our futures are expendable, that our cultures are collateral damage, and that our future generations will inherit a world diminished by the action of others. The drive behind each intentional move was our fight to close the existing gap of understanding the experiences of people and communities and the normative practices of the international community. How do you translate the urgency of loss? How do you capture a millennia of experience and practices into a few lines of text? More importantly, why was this required for frontline communities simply to be heard? The answer was never to simplify these realities for convenience, but rather to demand the appropriate utilization of these experiences. The gap between the visceral reality of climate change in the Pacific and the abstract deliberations of multilateral spaces is not merely lexical. It is profoundly human, and this was the motivation behind the campaign, because it required constant effort. And in the constant effort, you find what the climate ICJ advisory opinion means to our blue Pacific. For young people from the Pacific, those here and back home, it is the culmination of 6 years of carrying out our duties to the land and the seas. For the Pacific, it is about giving a system that has disregarded our people and giving it one more chance. At its core, this is what the fight for climate justice is to us. With these words, I'm very, very happy to begin our discussions today. And first and foremost, we have a very, very excellent, very, very high level lineup of speakers who will be providing introductory remarks and further grounding our sessions before we go into a round of discussions with our panelists. And so first and foremost, I have the honor of introducing or inviting Her Excellency President Musar, who is the President of Slovenia, who will be delivering her introductory remarks by video. So we'll ask the tech team to play the video for the President. Thank you.
Ladies and gentlemen, it is my great honor to address you today. My statement was recorded just after the ICJ issued its advisory opinion on obligation of states in respect of climate change. Your conference is thus very timely, and our resort to modern technologies to cooperate could not be more justified. I must start by saying how proud I am that Republic of Slovenia supported and participated through this process leading to yesterday's presentation of the advisory opinion. As a participating state in the advisory proceedings, Slovenia strongly supports the court's recognition that a clean, healthy, and sustainable environment is a human right and that underpins the right to life, health, food, water, and above all, dignity. We are encouraged by the Court's clear articulation that states have legal duties to take ambitious climate action, prevent transboundary harm, and cooperate internationally in addressing climate crisis. I believe the Court's opinion is a significant contribution to the development of international law and will serve as an important guidance for states as they shape and implement their climate and environmental policies in line with international commitments. Slovenia remains firmly committed to multilateral cooperation and the strengthening of legal framework that contributes to the effective protection of environment and the well-being of all people. This is the first ever ICJ case on climate and at the same time, its biggest case. As it has been suggested, these advisory proceedings are unlikely any that have previously come before the Court. The Court's opinion is most relevant for those most affected by climate crisis, small island states. Once Vanuatu and others put forward the two pertinent questions, we could only recognize their validity and support it while trying to help prepare grounds for the Court deliberations, together with all other intervening states. The advisory opinion delivered by the Court's President, Judge Yui Iwasawa, is historic. It is visionary, bold, yet firmly rooted in existing law, and it is sufficiently concrete to provide useful guidelines for us, states. The Court put forward what I can safely conclude, a definite international standard on climate and environment protection based on all relevant treaties and customary law. The advisory opinion is most timely before the Belém COP30 later this year, with the reminder that ambitious and progressive nationally determined contributions are needed to keep the 1.5 degrees Celsius alive. In short, the Court addressed both questions posed to it by the UN General Assembly in the strong and clear affirmative. The Court fully raised to its legal challenge on climate crisis, and now the turn is back on us, states, to rise to our domestic and international challenges to mitigate the climate crisis and better adapt to it. This groundbreaking advisory opinion provides a clear guidance what is the best way to move forward. Indeed, a lasting and satisfactory solution requires human will and wisdom at the individual, social, and political levels to change our habits, comforts, and current way of life in order to secure a future for the generations to come. Thank you from the bottom of my heart.
And we thank Her Excellency and her team for the wonderful message and for bringing the very important message on the right to healthy environment and a call to action for countries and the responsibility that we bear in carrying this advisory opinion forward. Our second high-level speaker is also someone who does not need an introduction, but is none other than the Honorable Ralph Regenvanu, the Minister for Climate Change, Adaptation, Meteorology and Geohazards, Energy, Environment and Disaster Management for the Republic of Vanuatu. Honorable Minister, we'd like to give the floor to you. Thank you.
Thank you, Vishal. Excellencies, colleagues, friends, allies in this fight. Today is not like yesterday. Today is different to yesterday. We've shifted things. We've created a new baseline for climate policy going forward, for climate action. And I want to say thank you to everybody who was involved. I want to say thank you to the youth. You know, this was a crazy idea. States would have never come up with it themselves, right? We needed these youth to say, this is something that we can do. And in the end, we did it. Yesterday, we did it. We achieved this crazy idea. And today, the 24th of July, is National Children's Day in Vanuatu. I can't think of a better gift we've given to the children of Vanuatu than what happened yesterday and the future generations. With this new baseline, I think it gives us hope that we can make these changes to the most complex systems, you know, the highest level of world affairs. can be influenced by the youth of the Pacific, the youth of the world, future generations. So we need to grab this inspiration and move forward now, because we now need to make sure that all countries fulfill their legal obligations as defined by the court. We need to make sure that they step up and don't try and create some mismessaging of what came out yesterday. And I think it's important for all us to continue to try and keep states honest and make sure that this advisory opinion is realized to the fullest extent that it can be. Vanuatu is now working on a resolution to take back to the General Assembly to implement this decision, and we are calling upon us all who are part of this movement to help us get states to endorse this new resolution that will be going through. And we hope also that by the time we get to Belém, this advisory opinion will have permeated through all the understanding of everybody who's at those negotiations, because there are certain arguments that can't be made anymore. Some arguments that we've been come up against for decades, they can't be made anymore. And we don't want to be in front of people making outdated, unlawful, illogical arguments that have been rejected out of hand by the advisory opinion, 15 judges in unanimous accord. It's so strong. Let's continue to stand together, and let's make sure it happens for our future generations. Thank you so much.
Thank you so much for those remarks, Minister. Our third high-level speaker is Her Excellency Mary Robinson, the first woman president of Ireland, former UN High Commissioner for Human Rights and member of the Elders, and she's joining us virtually online. And just checking if Her Excellency, you can hear us?
Yes.
Okay, thank you so much. We'll pass on the floor to you. Thank you.
Thank you, and warmest congratulations to the Pacific Island students fighting climate change, to the world's youth for climate justice, to the government of Vanuatu and the minister who has just spoken, and all those who stood steadfast during this entire process. When you first took on the world's biggest climate case, I saluted you for being bold and brave. But like the minister, I also felt it was a bit crazy. I knew how much work you'd have to do. And you went on to build a remarkable consensus in support of the campaign. The UN General Assembly was unanimous in asking for this ICJ referral 2 years ago. Yesterday marked a breakthrough global victory, one that we owe to your leadership, all of you. The International Court of Justice has spoken unequivocally and powerfully. It has made clear that governments and corporations must urgently step up, protect people, and take full responsibility for the climate harm they have caused. This moment ushers in a new era of accountability for major emitters. Let's make sure it reverberates around courtrooms worldwide. As climate disasters continue to wreak havoc around the world, displacing families, destroying livelihoods, and eroding hope, this ruling stands as a guiding star. It shows that existing international law is not silent on the climate crisis. Quite the opposite. It demands action. It defines the path towards a just and livable future, and it makes that path a legal obligation. This ruling gives us a powerful new tool to hold polluters to account. Let's use it. The era of impunity is ending. There can be no more hiding behind delay, denial, or inaction. Human rights have been unequivocally upheld by the advisory opinion, as the President said. The court has made it unmistakably clear. States have a vital duty to take bold and ambitious action to protect our environment, especially our climate system. This isn't just about policies or politics. It's about ensuring that every person now and in the future can experience effective enjoyment of their human rights. As the court powerfully reminded us, the environment is the very foundation of human life. It's what sustains our health, our well-being, and the future of generations yet to come. Over the next few months, let's use this ruling to spur stronger, nationally determined contributions and energize the negotiations at COP30. The opinion is particularly strong on states' mitigation obligations. They found that merely having an NDC is not enough. The content is just as important and must be consistent with the 1.5 degrees Celsius goal. And it could now be an internationally wrongful act to license, produce, or subsidize fossil fuels. Let's make this count as countries develop their climate plans. In Belém, I hope the ruling will empower the voices of the most vulnerable in every negotiating room. It should help to unlock some of the most contentious issues, particularly on fossil fuels, on finance, and on loss and damage. Let's carry this ruling forward with urgency, with integrity, and above all, with hope, because justice is no longer a distant demand. It is now the law. Thank you.
Thank you so much, Your Excellency, for those very, very inspiring words. We thank you for taking out your time as well and being with us for this program. Our next high-level speaker is His Excellency Arnoldo Brenes Castro, the Ambassador of the Republic of Costa Rica to the Kingdom of the Netherlands. Your Excellency would like to give you the floor. Thank you.
Your Excellency Mary Robbins, former President of Ireland and former UN High Commissioner for Human Rights. Your Excellency, Mr. Ralph Regenvanu, Minister for Climate Change of Vanuatu. Ladies and gentlemen, colleagues and friends. Allow me to begin by expressing my sincere appreciation for all of you being here today. Climate change is already affecting millions of people around the world, especially the most vulnerable communities. Extreme phenomena such as hurricanes, droughts, heat waves, and rising sea levels are causing widespread destruction and suffering. Scientific evidence is clear. Human activity, particularly the excessive emission of greenhouse gases, has accelerated this process, and the effects are felt in every corner of the planet. The damage is not only environmental, but also economic, social, and cultural. In this context, yesterday marked a historic day in international law and environmental protection. The International Court of Justice, the principal judicial organ of the United Nations, delivered its revolutionary advisory opinion on the obligations of states with respect to climate change, where there was a clear recognition of the right to a clean, healthy, and sustainable environment as a human right, among several relevant elements contained in the advisory opinion. I'm proud to recall Costa Rica's leading role in the process, aiming both at the adoption of the General Assembly's resolution declaring a human right to a clean, healthy, and sustainable environment, as well as the General Assembly's resolution requesting the court to refer to the obligations of states in respect of climate change through this advisory opinion. In close partnership with Vanuatu and other countries, we were aware of the paramount importance of this initiative since the very beginning. We thank and recognize Vanuatu's unceasing and unwavering work and leadership, especially our joint collaboration both in New York and in The Hague. Climate change is not the story of a few countries. The protection of the environment is a collective effort, a truly global convergence of will. Governments, international organizations, and civil society, we are here today together as equal partners. We are united by a shared vision and commitment to reaffirm our dedication to a healthy environment for all. In light of this, it is that I am also proud to acknowledge the crucial role played by the youth in this process, particularly that of the Pacific Island students fighting climate change and the world's youth for climate justice. It is encouraging to see what dedicated and committed youth can achieve. As active participant in the ICJ's proceedings, a supporter for international law and multilateralism, and having in mind our long-lasting and well-known commitment to the protection of the environment, I have entire confidence on the positive influence that this advisory opinion will have for the future action of states, the United Nations, other international organizations, and actors in order to better address the consequences of climate change. Today, we'll analyze the advisory opinion's implications. We will reflect and share perspectives on what this outstanding judgment means for the future. In this regard, I want to welcome also our high-level speakers. Let's continue to engage with each other. As today's event shows, this is not the end of the road. It is the bridge to the next phase of action. Thank you.
Thank you so much, Your Excellency. And as His Excellency mentioned, time to dissect this advisory opinion. And we have an excellent lineup of 7 panelists today who will be joining us in speaking further and taking us further into the advisory opinion. I'm going to ask all our panelists to kindly take the seat in front. Perhaps I'll just introduce them as they come up. First, we have Professor Margaretha Wewerinke-Singh, Associate Professor of Sustainability Law at the University of Amsterdam. We have Julian Aguan, Founder, Principal Attorney of Blue Ocean Law. Coral PISFCC, Director of Climate Change and Sustainability at the Pacific Community. We have Benjamin Shasta, Coordinator, Environment and Climate Change Unit, Office of the United Nations High Commissioner of Human Rights. Kate Wilson, Legal Officer, Department of Sustainable Development, St. Lucia. Bruce Radike, Legal Advisor, AOSIS, and Jennifer Robinson, Barrister at the Doughty Street Chambers. Can we please give a round of applause as all our panelists make their way forward? Thank you, everyone, for joining us on the panel. And so we wanted to start or make this as a conversation amongst us as we talked through some of the key findings of the ICJ and the advisory opinion. And we wanted to begin with Professor Wewerinke-Singh. As counsel for Vanuatu, in your opinion, what would you say are some of the key legal takeaways from this case? And what would they mean for litigation, negotiations, and campaigns as we go forward?
Yeah, that's a great question. And to answer it, let's go back to what our hopes were about what the court would be able to contribute as the principal judicial organ of the UN, the highest court in the world. It's a court with general jurisdiction, and it's so the court was and is uniquely positioned to make sense of all these different obligations that exist on the international law of the sea, climate change law, human rights law, customary international law, etc. And the hope was that the court would interpret these obligations in a way that would make all of these obligations stronger, to make something that would be more than the sum of its parts. The court has done that. It has beautifully delivered on that promise. So the court has shown how this kind of tapestry of obligations culminates then in obligations of states that are stringent, that set stringent standards that apply across these different areas that need to be interpreted in a harmonious way that then leads to kind of the highest level of ambition that you could distill from these different obligations. And to do that, it used essentially all techniques of interpretation that are available under international law. So looking at the object and purpose of treaties, ensuring systemic integration between these different obligations, etc. And it's done it so well that it ended up concluding that even if a state hasn't ratified a climate treaty, it still is under these same obligations. That's quite remarkable. So I'd say that this mosaic or this web of obligations as a really unique contribution that can be used in many different ways, precisely because of the comprehensive nature of it.
Thank you for that, Professor Margaretha. And I think it builds on to something we were speaking to earlier as well around the broader implications for this advisory opinion, which some of our high-level speakers also touched upon. I'll go to Julian for this as well. You've also been at the heart of this campaign. What would you say are some of the broader implications of the advisory opinion for frontline communities, peoples, and for all of us?
Yeah, this opinion was awesome. It gave us so much of what we needed, but actually I would really like to bring into the room just one community, because that was our approach at Blue Ocean Law when we first 5 years ago decided to do this and we embarked on this journey. We wanted to, from the outset, collect communities, collect testimony from frontline communities who are already reeling from the many adverse effects of climate change. Vanuatu has so many of them. And one story in particular that we went to was so haunting, but I want to bring it into this room because it really sort of gave us the momentum to keep going, and then we expanded and we went to all of the different islands and collected testimony over half a year. But basically, there is, on the island of Tana in the Republic of Vanuatu, a community called Yakel. It's a custom village. This means that the people largely live traditional lifestyles today. And the amount of, the distress has grown so acute, especially for the women of this community, which have several responsibilities and cultural responsibilities to the community to provide for the Nahunu traditional. I wrote this in the Rolling Stone article about a week ago, but really this was so shocking because we found out once we gathered the women and separated them from the rest of the community, and they really started pouring out their hearts, and they are dying from a broken heart at this point. Their distress is so acute, they are actually suffering several strokes and premature death. Because of climate change, and their arable lands are now gone. There hasn't been a single successful yam harvest in 4 years, and now they have to climb down one side of a steep mountain, cross a frequently flooded ravine, climb up another side of the mountain just to reach the arable lands where their relocated gardens now grow. The strain, both physically and spiritually, because they are unable to often make it back by sunset, meaning they are unable to fulfill their cultural roles to provide for the Nahunu. They are unable to bring food back for this ceremony, and that's what's happening. And so for us at Blue Ocean Law, we considered it a sacred duty from the outset to articulate these harms as human rights harms, because that's what they are, and to bring it to the judges of the World Court and to make it really clear that this is what we're talking about when we're talking about reparations or things as simple as restitution, ecosystem restoration. We would like that arable land to be restored closer to their actual villages where they actually live so they can continue on living. And what they're really fighting for, right, is not only their right to live in the world on their own terms, but their children's right to do the same. So I think that is the most exciting part of this, seeing how frontline communities like the women of Yakel, like so many other communities we spoke with, are going to use this ruling to actually wrestle that world, that other world, that future that they need, that they deserve, and that they are legally entitled to hasten it into being. Thank you.
Wow, thank you so much, Julian. That was very beautifully said. And it's an amazing article in the Rolling Stone. Strongly encourage everyone to go and have a read after this as well. Moving on, we'd like to come to another very important part of the advisory opinion that was brought up yesterday, was the strong focus on the science. And Coral, as a scientist from the Pacific, what are your thoughts on the ICJ's pronouncements on the best available science, and what would you say, and how do you think this would help climate action going forward?
Thanks, Vishal. Yeah, I mean, it's fantastic. They basically said science is the law now, which is great, and the IPCC is that central benchmark. So all the naysayers that produce very interesting articles in science countering climate change really fade out completely now. I think the other critical component of that was recognizing that it's 2 degrees as a target or a goal under Paris actually is the upper end. We need to keep it well below actually 1.5. They also acknowledge that even at 1.5, it is not safe for many communities and ecosystems. And we know from the Pacific, that's our people. That's our lowest lying atolls, our lowest lying communities, etc. So, and we know from experience that we've already suffered significant loss and damage that is irreparable and irreplaceable. And that includes both economic and non-economic losses. And Julian's just spoken to a number of those. So on one side, it's really important that the NDCs now are benchmarked at least to 1.5, but the lawyers will tell you, lots of the decisions also mean that there's a historical responsibility associated with that, and the ambition levels need to be absolutely meaningful and followed through and reported on. So that's really important. On the science side and the importance of science, for the Pacific, we translate science not just as modern science, but as traditional knowledge and lived experiences. Our area of the blue Pacific continent is massive. It covers over 20% of the world's exclusive economic zones. That's a huge portion of the earth. We will never have all the modern science to be able to tell every story that needs to be told about the impact of climate change and the loss and damage associated with that. We have over 4,000 years of traditional knowledge that has been passed down over generations. Our cultures are not written, they're oral. So they're passed down from mouth to ear through generations, and that preservation of traditional knowledge, the capture of that in meaningful ways, and the combination of that with science to make informed decisions is critically important. And the manifestations of the impacts of climate change and the loss and damage in our region are very unique and unlike anywhere else in the world. And if you look at the science that we have now, I'll take tuna, for example. We can now model the movement of those stocks outside of the exclusive economic zones of our countries into the high seas, where ironically they're being caught by countries who are polluting, and they take them for free now. And they will continue, and that will increase over time. So there's a massive economic impact for the region. But then there's what existentiality actually looks like. And people use that word very flippantly. They don't actually know what it means until you come to some of the communities in the Pacific and some of the lowest lying atoll nations. With the modeling that we have now, and my colleague Lisa at the back has a 3D model of the Republic of the Marshall Islands, that we've combined our latest science and modeling to show what does it actually look like when you get to 34 centimeters. So by 2050, 2060, what does that ruler size actually do to a country? And you'll see on there that becomes existential. It is not the 2100 time mark that we're looking at in science. It's within the lifetime of our own people now, and certainly within our children's lifetime, that the 1 in 10 year event is exacerbated by 34 centimeters to become existential and something that you would only expect to experience once in 100 years. And then instead of happening only once every 100 years, it happens every 5 years. So water reservoirs cannot survive that. Taro patches and pulaka patches cannot survive that. And so long before our countries go below water, they become unlivable when you combine the science and the traditional knowledge that our people have. And so it is that evidence really that we need to use now to show what are the tipping points of loss and damage, what is the cost of not providing enough climate finance to a country now to adapt, and what is the cost of global inaction in mitigation and the ambition. And so it brings me to the final point, and I'm not a lawyer, I'm just a scientist. But for me, this is where, you know, listening to the final conclusions around reparation and compensation are critical. We have to bring that evidence to the table to show what the real cost of inaction is, and at what points can we no longer repair those critical infrastructures, those critical ecosystems, which are tied to the human rights, not just of our people, but the future generations. And so I really look forward to this being the turning point, Minister, that you talked to. We now have to really apply it. One of the big challenges that we have in the region, there's just not enough people. So we've got good evidence, we're developing that, but it's hard to get that into the IPCC process. And for those of you who know the IPCC, that is already watered down. And as a scientist, we are taught to only say something when we're 95% sure. We're at the point where actually scientists have to give their opinions as well, because we need to get that science and evidence out there as fast as we can, and we need to get it into this process, which the court has now said sets the benchmark for action going forward and for compensation and reparations. Thanks.
Thank you for that intervention, Coral. And for everyone, the model that Coral mentioned is at the back, and you're welcome to have a look at it after the event finishes. And it's a very visual, very graphic, but very real picture of what the impacts of climate change mean for community and what science is able to now tell us about it as well. We're also very fortunate to have Ben join us online, and we'll maybe just go to Ben to speak about the human rights discussion or the human rights angle of the ICJ's advisory opinion. There was a lot talked about in the ICJ's opinion on, and there was a significant pronouncement on the applicability of human rights. Could you perhaps reflect on these dimensions and the implications of the advancement of human rights protections in relation to climate change?
Yes, thank you very much. It's such an honor to join this distinguished panel with so many friends and partners. And first of all, I just want to say yes to everything said before me. This is about people. It's about the right to science. It's about all life now and the future. And it's about putting a stop to the preventable miscarriage of justice that climate change is. Earlier today, my boss, the UN High Commissioner for Human Rights, issued a press release in which he described the ICJ advisory opinion as an authoritative, clear, and indisputable affirmation of the far-ranging impacts of climate and the broad extent of obligations of states under human rights law and beyond to act urgently to stem the damage. And in responding to your question, I'd like to just unpack that statement a little bit. This opinion affirms an understanding of the application of human rights obligations in the context of climate change that is consistent with the work of the UN Human Rights Office in this area over decades. The court extensively referenced the work of UN Human Rights Office and other human rights mechanisms at international and regional levels, and its opinion reflects the extensive and well-reasoned submissions and statements of governments and other actors to the process, all of which is a testament to the collective efforts of the climate justice movement. The court found that a wide range of customary human rights and environmental laws and treaties conveyed legal obligations with respect to climate change, and that these obligations go beyond commitments in the climate regime themselves and apply to all states regardless of their ratification of climate treaties. It reaffirmed the right to a clean, healthy, and sustainable environment as a human right, noting that environmental protection is a precondition for the effective enjoyment of all human rights, and that a wide range of rights, including to life, health, an adequate standard of living, privacy, family, home, and the rights of women, children, and indigenous peoples, among others, are adversely affected by climate change. Building on existing work by the Human Rights Committee, the court recognized obligations to protect the rights of persons displaced by climate change. And it found that a breach of state obligations under international human rights law to respect and ensure the effective enjoyment of human rights by taking necessary measures to protect the climate system and other parts of the environment constitutes an internationally wrongful act. In describing state obligations to exercise a stringent standard of due diligence with respect to climate change and its human rights impacts, the court highlighted that states must effectively regulate private actors' emissions. And the ICJ was unequivocal in finding that a full range of remedies is available for climate harm. States in breach have duties of cessation, guarantees of non-repetition, and to make full reparation, restitution, compensation, and satisfaction, a position which is consistent with the recent report of the Secretary General to the Human Rights Council on loss and damage, for example. The court even highlighted examples of climate-specific remedies, including reconstructing damaged or destroyed infrastructure and restoring ecosystems and biodiversity and compensation. Per the opinion, states have to exercise this stringent standard of due diligence in fulfilling all of their human rights obligations related to climate change, including with respect to mitigation, adaptation, loss and damage, and international cooperation. In doing so, states should be guided by, among other things, equity, including intergenerational equity, sustainable development, precaution, and common but differentiated responsibilities, including historical responsibilities, as well as the best available science and the highest possible climate ambition. And they need to take specific steps like developing and implementing progressively ambitious nationally determined contributions under the Paris Agreement. Commitments that are consistent with an adequate contribution of each state, taking into consideration the aforementioned principles to collectively achieve a target of no more than 1.5 degrees Celsius of global heating. In other words, this opinion is a game changer, and only if we act now to ensure the action needed to implement it, stop the climate crisis from worsening, and ensure reparations for those affected, can we make the changes we need happen. So with an eye toward COP30 and beyond, I look forward to working with all of you to advance climate solutions that, in line with this opinion, are grounded in human rights, including through legislation, policy change, resource mobilization, and international cooperation. Thank you.
Thank you so much, Ben, for those reflections on human rights. Truly, it was a big day for human rights at the ICJ yesterday, and a game changer, really, as you said. We've got 3 more panelists before we open up for questions. So if you've got questions, this is the time to think those through, get those ready. But we wanted to turn to Kate for a question to you. I think St. Lucia's intervention was very powerful at the ICJ, and there are a couple of fans for your intervention in the crowd, I know, most certainly. But it was great to see St. Lucia's very powerful intervention. But also something that was unique to this advisory opinion was this was the unique nature of the collaboration and coordination that was present between civil society, governments, and regions, etc. Would you like to reflect that on the nature of this coordination, collaboration, and how that led to the success of this advisory opinion, or the strong outcome that we saw yesterday?
Yes, thank you very much for that. Thank you very much for that question, which I'm so happy about, because often we see the end result of something and we do not know how much goes into getting this thing looking as brilliant as it looked then, according to you, of course. So it also gives me an opportunity to say thanks from the bottom of my heart to all those who worked together with us to ensure that we made this contribution and we got this result that we got yesterday. So I want to do this at 3 levels. First, I want to look at the national level, who we collaborated with and who assisted us, and of course, the regional level, and then the international level, because without those, we could not have made it. So first and foremost, I want to talk about my team. This brilliant team of ladies, coordinated by Dr. Janives Remy, who is the director at the Srinath Rampal Center in Barbados, Caville campus, who helped us to put our written statements together, our written comments together, using this wonderful imagery of the girl, the child, Helen the child, in the petticoat, in our national colors, submerged in sea level rise. And of course, using the words of our Nobel laureate, Sir Derek Walcott, the sea's history, to show how, the impact of climate change on St. Lucia. So we want to thank Rochelle John Charles from the Aegis Chambers, who was part of our team. And of course, I want to look at my department, the Department of Sustainable Development. We would not have done it if we did not get the authorization from our Honorable Minister, the Honorable Sean Anton Edward, the Minister for Sustainable Development, and of course, our Honorable Attorney General, Mr. Leslie Mondesi, who, once we came to them and said, listen, we want to have a shot at that, who had, left nothing unturned and said, let us do this, and give us, of course, the resources to do so. I want to thank also our Chief Sustainable Development Officer, Mrs. Dawn Pierre Nathaniel, who gave us all the UNFCCC reports, and, all the groundwork, because, of course, she and her climate team are the ones who go out and advocate for us on climate change. So give us all that groundwork, and I want to thank them for that. Of course, our Deputy Permanent Secretary and, of course, our Permanent Secretary, Mrs. Anita Montoot, and Mr. Jim Xavier, because again, if we did not get that sign of our note verbal and all those things, we would not have been able to do it. Our Ministry of Foreign Affairs in St. Lucia, and of course, our permanent mission in Brussels, the Ambassador Raphael Joseph and the Charge d'Affaires, Mr. Desmond Simon. We could not have done it without him, because, we were up late at night compiling all those pages together, stapling, all those things together. The OECS, we were going crazy trying to get this thing on time. And those two guys, they not only fed us, but they ensured that we were here on time, that our packages went off to the registry on time. And I want to thank this young lady here who I see smiling, Miss Leanne Sackett from Vanuatu. I always, and I think I've said so to her, I admire how calm and cool she is in those circumstances, because I'm about to get crazy trying to get this thing done. And she's so calm and cool, and she's always there. Let me help you. I'll have some time to read it for you. And she provides us with all those documents and is always there to assist. So I want to thank her and her team. I also want... the brilliant collaboration from the Organization of African American and Pacific States. We have Crystal Pratt. We also had Christine, Miss Newman, or Cheryl Newman, who was there with photocopying early into the wee hours of the morning, ensuring that we had coffee, we had tea. We were here at Carlton Ambassador, and this place was transformed. We had no cares, because we had food, we had everything that we needed to do just what we did. So I want to thank them as well. Okay, on a regional level, CARICOM, we want to thank the CARICOM Secretariat, because they provided the resources we had 3 write shops before we were able to get to this process. We had the write shop in Grenada, we had one in New York, and we also had one at the University of the West Indies, Barbados. So I want to thank persons like Justin Sobian. We want to thank Dr. David Berry and his team at UWI, because without them, we could not have put this thing together. They were brilliant in giving us, this whole imagery of how to do it in this narrative fashion and so on. So this St. Lucia girl that you saw submerged was all a result of all of that. OSS, Bryce and your team, okay? If you did not give us the financial support, we would still be in St. Lucia. We would not have been able to. So thank you for that. And I also want to thank my Caribbean colleagues, because sometimes we look at just, the physical work, and we forget the human aspect of it. And it was, I was able to see, the court has spoken about the duty to cooperate. And I saw this in action when we were putting this together. Because St. Vincent, if they were behind, St. Lucia team did, everybody chipped in to assist to ensure that they were on time. There were persons who didn't get their luggage, and so we had to borrow gowns and we had to borrow wigs to each other, and you saw each other helping each other put their makeup because everybody was in a hurry to do this. So the cooperation and the camaraderie was tremendous. I want to thank persons like Vanika Sobers Joseph of Dominica, Shernal Hideaway, who was the delegate from St. Vincent and the Grenadines, and all the OECS countries who, I mean, unfortunately, they're not here today, but who went so far into making this a wonderful, wonderful presentation in December. And finally, I just want to thank all of you here, online, and generally, who just, you know, with just a little word of encouragement or anything that you said to us that gave us this impetus to action. And we pleaded to the court, and we were able to get this wonderful landmark decision that we got yesterday. So thank you so much for that opportunity.
Thank you so much, Kate, for those words. Truly does take a whole village, and thank you for bringing that into perspective in your discussion. So what it really takes to make a submission at the ICJ, and we're very grateful for those insights. We will turn to Bryce, and the perspective of AOSIS was very critical to the ICJ proceedings. And yesterday we saw some huge pronouncements on sea level rise, legal protections for island nations, continued statehood, and beyond. And so, what would you say is the path ahead for AOSIS with all of these pronouncements, and especially on AOSIS's response to the advisory opinion of the court yesterday?
Thanks, and I really feel for the country that had to come after St. Lucia in the pleadings, as I now have to come after Kate. So obviously, it's been said a number of times here, this decision is a fundamental turning point in international law in relation to climate change. I don't think that we can underplay that at all. And I think there are really sort of three key things that I want to highlight here. So first, for too long, for literally the history of international law has responded to the interests of large states, powerful states. But with this advisory opinion, we see that that is changing. Inspired by students, brought by small states, we have the highest court in the world speaking to the interest of small states. And I think this actually says something about the changing nature of international law. So this was not actually the first attempt to go to the ICJ. More than a decade ago, Palau tried to bring a similar advisory opinion, and they were crushed by developed states barely before it got out of its infancy. So things are changing, and I think the numerous ways that this decision refers to, in some ways, the lived reality of small states and their needs, and how international law needs to respond to them is really important. So second, on this question of sort of sea level rise, a lot of AOSIS's legal advocacy for the past few years have been focused on sea level rise, the concept of permanence of maritime baselines, so allowing small states to retain their maritime resources, and ensuring the continuity of statehood in the situation where states are inundated by water, all or less than all. There was actually some strong pushback on AOSIS bringing these ideas to the court. Some people were saying, this doesn't really fit in. But we were fairly confident that this was something that the court would like. The court deals with boundaries, it deals with statehood. And so we took a chance, and in this case, we think it paid off, obviously. The ICJ says that statehood is essentially permanent. They added some wiggle words there, which we'll ignore. But this is really helpful because back in New York, Next year, there'll be a high-level event on sea level rise. And member states have already agreed that there will be a political declaration for this high-level event. And so now to have the ICJ say, one, that baselines are stable and permanent, and that statehood is continuous, it's going to really make it easy. Well, we hope it really makes it easy, but it's really going to allow us to push back against those states that don't hold this sort of more progressive interpretation of international law. And the last, and this is sort of maybe a more technical legal issue, is that the court said that COP decisions, the court says that, that COP decisions can change the legal nature of obligations in the Paris Agreement. And this is really quite revolutionary because our sort of operating understanding for the last decade of the Paris Agreement has been that we can clarify obligations, but we can't change the legal nature of them. And in this case, the court said all of the work that we have done on pushing 1.5, all small islands pushing 1.5, means that that actually is the legally binding target. So this creates great opportunities for us in climate negotiations. It also creates danger as well. So both, I think, in New York and at climate negotiations, there are many avenues to take this decision and really operationalize it.
Thank you, Bryce, for that, and for those reflections around what it means really for small island states. Before going to questions, we'll turn to Jennifer. And we've recently, I've got the word transformational thrown about quite a lot with this advisory opinion. And there is a very strong or very transformative potential of this advisory opinion. And to sum up our discussions, what would you see as the transformative potential of the advisory opinion for the advancement of law and climate accountability going forward?
Thank you for the question, Vishal. I want to first speak about process and representation because I think that's essential in understanding both how we got this transformational decision, but also in how this is, the process itself is transformational for international law. So as the UN Secretary General said, this is a victory for the planet, for climate justice, and for the power of young people to change the world. And so I want to acknowledge you and Cynthia and the students and the youth movement who made this possible. One of the most inspiring moments for me in this entire journey was sitting in the UN General Assembly with Julian and the Vanuatu team when leader after leader stood up and said, thank you to the youth for standing here, for demanding this action from us. And I have never seen in international law, which is too often so far removed from communities and social movements, a social movement brought into the room in that way. And that is, I think, transformational, not just for what it means for this case and the outcomes, but also for what it means for all young people who will feel empowered about their sense of agency to change the world because of what they've seen you do. So I think we should have a round of applause for that. I also want to talk about the principled leadership of Vanuatu and Minister Ralph, and the role of global and Pacific solidarity in this process. So I had the privilege of representing Vanuatu in its first ever appearance in the International Court in the Chagos Islands proceedings. In that case, Vanuatu played a role where their submissions were reflected in the judgment of the court, which showed the contribution that small island states can make. But I think also to go from its first appearance to leading this entire initiative is a remarkable achievement led by Ralph and his energy and activism, which I think is why we're here today. And too often international law, and for too long international law has been the preserve of powerful states. And the fact that Vanuatu was able to pull off what superpowers couldn't is a huge testament to you, Ralph, and to you, Ambassador Tevi, and the entire Vanuatu team. So, and that wouldn't have been made, a round of applause for that too. But that wouldn't have been possible without Pacific and global solidarity. And we've heard a bit about the OACPS today and what a powerful bloc of states that is in terms of mobilising UN action. So I want to thank the team who are here today and recognise the role that they play and can continue to play on important principles in developing international law. But the choices that were made in this case in terms of legal representation too, and I want to recognise Ralph for choosing a local Pacific law firm in Blue Ocean Law, and Julian working with Margaretha, who have been an incredible team to have led this initiative. I'm proud to have worked with you. But in the ICJ decision case in the Chagos proceedings, the president of the court remarked on how it was the first time so many states had participated in the court, but also the diversity of faces presenting to the court. For too long, international law has been the preserve of privileged white lawyers in London, and we saw that change with Chagos, and this case saw a sea change. And I think that is incredibly important in terms of transforming international law and who it's for, who it serves, and is why we got the decision that we got yesterday. In terms of its transformational potential in terms of law, this is going to inform domestic, regional and international decisions all over the world. And for me as an Australian lawyer, I know that it's going to shape the way that we do advocacy at home. It already is, and we'll see that replicated around the world. So I'm excited about what we can do with it. I can't wait to continue to work with you all on that. And before I finish, I want to give one last thanks to SPC, because working with Vanuatu and the Marshall Islands, the support that was provided by the SPC was remarkable in terms of helping those small island states. I saw it firsthand with Marshall Islands, using their modelling and scientific knowledge and understanding and helping us as lawyers to articulate that in court. Sitting in court and watching the judges react to the Marshall Islands presentation, I was watching them closely, and the looks on their face when they saw the inundation, the modelling and the inundation that was presented so effectively by Kathy for the Marshall Islands, really made a difference. And I think that that impacted upon the findings we had about 1.5, that it's not safe, and the very strong findings on customary international law and the principle of prevention. So I want to thank you for the role that you played. Coral, my amazeballs friends. Hearing the word amazeballs in the international court was not on my bingo card for 2024, but what a great service that you've provided to all of the Pacific Island states. So let us all continue to work together, because I think the transformational potential of this process and the decision implementation is where it's at now, and let's make that transformational.
Thank you so much, Jennifer. And with that, we'll like to open the floor for some questions. We're going to take the first round of questions, perhaps 3 questions from the audience for our panelists. So if you have a question, please raise your hand, and there'll be a mic that'll be brought to you, and you can ask your question. There's one question there, if there's and one at the back, and a third one here. So the first round, we've got 3 questions, and then we'll let our panelists respond. And if you can please direct your question if there's a specific panelist you'd like to direct your question to.
Okay, firstly, congratulations to everyone. This is an inspiration to youth, but especially youth of traditional and indigenous communities, especially on the lines of Mr. Aguan and Ms. Pasisi. We work on the behalf of Amazonian indigenous communities. So our question is really, what is your advice for facilitating access for these communities to these state obligations, especially if they cannot make it to the negotiations in Belém do Pará? Thank you.
Thank you for that question. We'll take the one at the back.
Thank you, and congratulations on this massive achievement. My question is for you, Bryce. How are you potentially going to operationalize this decision in the negotiations for the plastic treaty next week? Obviously, plastics are made of fossil fuels, and we need to align our carbon budget on plastic production with this decision and with climate objectives. So, yeah, thank you.
Thank you for that question. And we have a question on this side of the house.
Yes, thank you. My question leads to somehow think about Belém, next steps, and also think about the advisory opinion of the Pan American Court, how it's combinable, how you would relate to that.
Okay, so we've got the first question with Coral and Julian, and then a question for Bryce, and then a third question, I guess, is for everyone, and it's open to everyone. So maybe we'll begin with Coral.
That's all right. Thank you, Julian. That's very kind. Yeah, it's a really good question. And I think Julian spoke to some of this already in capturing the lived experience of those communities. And something that we're very privileged at SPC to be able to do is to work with Indigenous peoples, and traditional knowledge, culture, youth are a part of our mandate in the Pacific region. So it's our job to go out as we capture modern science, to capture the experiences and a lot of the knowledge that is held not just in youth, but in the older generations, that we have to transverse this space and help to capture those in ways that are respectful of that knowledge. Unlike Western systems of validation and acknowledgement, the traditional processes are quite different. And so we have to understand how to capture that in a very respectful way to recognize and acknowledge the custodians of that knowledge, not an individual, but a community, and where that has come from, not just from that country, but across the region in the journeys that we've taken. So part of the process of supporting the Pacific Island countries from SBC's side was to help capture some of those stories and wrap that into science where there was science to complement, but also present it in its own right as standalone information. I think the important part now of taking this amazing outcome and translating and bringing everyone on that journey is what we're here to actually find resources for, because it's not easy to get the resources to help gather traditional knowledge and engage communities who have that. And we've already been asked by Vanuatu and a number of other countries to help convene a workshop as soon as possible to bring those stakeholders to the table to unpack this in plain English, in plain other languages that many of our countries operate in, to really ensure that people understand and communities understand what this means and how they can use that themselves as well to empower the situations that they are in. No one knows better the solutions to the impacts and challenges that they are facing than them, and we have to have our ears open. We have to translate this, but we have to listen to what it is that they want, how they want us to preserve this information for next generations. How do we respect those traditional protocols as well as protect them under international law? Thanks.
Thanks, Coral, for that. Julian, I don't know if you would like to go ahead.
No, that was great. No, but I mean, it was amazeballs. Just to add a tiny bit, I mean, so many outsiders, when they're coming into these Indigenous communities, as you know, always think they know best. They talk, they don't listen. All of those things happen. But what we found was the Indigenous peoples, as you know, are so incredibly clear about their own needs. And they already have translated fully in their minds, the whole process. They translated what justice means on their own terms. For example, some of the communities that we worked with, that we visited, very Bari, for example, in Papua New Guinea. My God, the stories that we heard. This is a community that has already moved 4 times, due to sea level rise. They're currently in the midst of their 5th and final climate-induced relocation. And I say final only because there is actually just no more inland left to go. But that's where we are, and they know exactly what they need. They know how they need to fortify their homes, and they need better poles, and they need all of this finance to do these specific things. They even have numbers attached to what they need. So that is the key. Just understanding that, according Indigenous peoples finally, once and for all, the respect that we all deserve, because we know what we need. And so that, and identifying with allies and funders who understand that and who wanted to facilitate that on behalf of, as partners and true collaborators with Indigenous peoples. That's the key for sure.
Thank you, Julian. Bryce, I think there was a question for you on the Plastics Treaty and the work going ahead with this advisory opinion.
Oof. So I think the decision will be quite helpful. So first, it puts polluting states on notice that there is a set of customary obligations that they will have to abide by, no matter if we get an agreement or not. So we heard the court talk a lot about stringent standard of due diligence. And there's no reason that that should not apply in the plastics context as it does in the climate context. The second is about the importance of science. And it's a little shocking how much science has been absent from the discussion on the plastics negotiations. And the science, although much of it relatively new, is increasingly shocking. Just a few weeks ago, there was an article that said that we have a spoonful of plastic in our brains right now. So hopefully this leads to a little bit of a reset so that some of those scientific realities can start to permeate the very little time we have left in negotiations. It, however, will also make it more difficult. In the process of negotiation, we often punt things till later for the COP to deal with if we can't come to a decision now. But if COP decisions now can have legal impact and can change the nature of obligations, it's going to make it much more difficult to agree to punt things if we know a year or 2 years down the line when we're not in the room anymore, someone else is going to make a decision that may change the nature of legal obligation. So I'm going to say it's going to be fun in Geneva, and 2 weeks from now I'll be entirely, well, I'm already entirely white. My hair will be entirely white.
Thanks, Bryce, for that question. For that response, sorry. We've got, I think we've got time for take 2 more questions in the room. We've got some online questions, so Seb for the online questions.
I'll lend my voice to some of the questions online. We have more than 80 questions at the moment, so I'll just cluster maybe some of them. One question is like a set of questions really relates to what comes next, in particular at the United Nations. What can be expected from the UN General Assembly resolution mentioned by the minister previously, and also how will the ICJ advisory opinion impact the planning and the agenda of COP30? And then the second cluster of questions perhaps relates to the implication of his very important ruling on the fossil fuel industry, even if they do not yet have their own climate commitments, and also to what extent the advisory opinion can further empower citizens to actually bring legal actions against this industry.
Thank you, Sam, for those questions. There's a whole host of questions. Just so everyone's information, there's about more than 600 people tuning in online watching this stream today. So we're very fortunate and very grateful for everyone online as well for joining us today. Yeah, I think it wasn't directed to anyone, so maybe I don't know if someone is willing to respond to the UNGA question at this point. Minister, I'm not sure if you'd like to speak further about the UNGA question. But if not, maybe we can come back to the comments later on. I'm not sure if you have any thoughts on the UNGA question.
Well, just to say we need to bring the question, the advisory opinion, back to the GA because the GA asked for the advisory opinion. So it has to go back and be adopted and accepted. But we also have an opportunity to make it something more than just acceptance, right? We can make an opportunity to be an ambitious call for further action. So that's what we need to work on now, is having an advisory opinion that can be supported by the majority of states and get through, but with the highest ambition possible. Thank you.
Thank you, Minister. And a set of questions around the fossil fuel industry. I'm not sure who wants to go first on this. Anyone willing to talk on the fossil fuel industry and what this means?
No, I have no idea what to say other than we now have we have the court performing its judicial function at the highest order, right? We have information now, and we have explicit textual references to fossil fuels, and not only in the ICJ opinion, the Inter-American Court of Human Rights, we have seen this momentum growing. I mean, and business as usual is over. I think now we can be more radical about everything. I mean, including going after the fossil fuels for everything. I mean, I don't really know what, I feel like in some ways lawyers have, yeah, I just feel like in some ways we have, as lawyers, a tendency to almost like lawyer inside the narrowest possible nook. It's like a conservative sort of impulse. I say, let's be done with that. Yeah.
Thank you for that, Julian. I don't know, Margaretha, there was a question on the fossil fuel industry and what this means about taking the fight for fossil fuel phase-out forward, the campaigns forward and the work forward, if you wanted to respond to that.
Yeah, it's high time, long overdue. So obviously several hooks, right, in the opinion. I think we see them regulatory through litigation, and of course this is also, if you look at the field of litigation, the area where perhaps most work still needs to happen, right? So again, there are some developments, early developments, but now it's really time to follow through and ensure that this body of litigation matures and ultimately translates into the proper transformation that we seek, which is really the end of this industry. Let's be honest, and reparations. So ensuring that these assets are used in a way that ensures that they end up with victims compensating them for the harm that this industry has caused.
Just, I think, very briefly, one of the things that I found incredibly interesting was the ICJ speaks normally to states, but in this issue, they were speaking to private actors and telling states, hey, you really need to regulate these private actors. So it's putting not just states on notice, but everyone on notice that this is the direction of travel. Get on board.
Thank you, everyone. I think there's one more online question. I will go to Seb for that.
Yeah, absolutely. There were also a set of questions related to the extent to which the advisory opinion addresses the principle of equity, both the intra-generational and the intergenerational aspects of this. If any of the panelists want to address this.
Yeah, that's a really great question, and there's several aspects of the opinion which are relevant, but just one that seems to have particular potential is the court's recognition of intergenerational equity as a principle that informs the interpretation and application of basically every other obligation that it has identified. So the effect of that pronouncement, of that recognition, could be really transformational, right? Because it means that for just to look at human rights, any human rights that is here has gains an intergenerational dimension, or actually has always had that dimension, but now we have the clarification that it is indeed the case. And so that means that we need to look at international law through a very different lens if we haven't already started to do that.
Any other panelists want to speak to the intergenerational element?
Yeah, just, I mean, from a science perspective, you know, carbon dioxide lasts 200 years. So already the harm that is being caused is going to transcend this generation. So I think the outcomes, as they speak to that, are just really helping to make sure that that harm that is yet to come, that from the pollution that has already in the atmosphere, that has historically been continuously pumped out, there needs to be, someone needs to be accountable for that. We're not even getting accountability for what is actually happening right now. And I know that we haven't raised this much here, but the access of our small island state Pacific to climate finance is absolutely pathetic. It's absolutely shocking when you consider that they are custodians of the largest blue healthy lung on the planet. So they are access the adaptation funds that they need to build and fortify their coastlines. So the loss and damage bill is going exponentially because they can't access the funds that countries are obligated to give them right now. And so I think we have to combine the injustices that we see right now with the injustices that are accumulating to the next generations. Because if you can't build a seawall fast enough now, the next generation is going to suffer and probably not even be able to live in the same place. And I love the fact that the judges said, well, you know, you can either repair the infrastructure or the ecosystem, but we recognize that you actually can't do that in some of these situations. So compensation is critical. But how do you compensate for the non-economic losses associated with displacing this generation and the generations to come? That's a very tough conversation to have, because I mean, I'm an Indigenous person, I'm a scientist, but most of my decisions are made based on my Indigenous knowledge and the fear of that knowledge not going to the next generation. And I can't quantify what kind of compensation is actually going to help us start to repair. And those are conversations that have to start now, right? We're not just going to come up with a solution like that. This is a conversational issue that has to happen between elders, between young people. And, you know, I think this is why it's so important that from here on out in the unpacking stage that we meaningfully engage young people in this discourse. We can't just bring them to meetings, and it has to be a much more meaningful engagement right from now through to the solutions that are complicated but really important. Thanks.
Thank you so much, Coral, for those very lovely remarks. And with those words, I think we are almost out of time for this lovely panel, but our guests, our panelists, our speakers would be available for further questions or discussions if you'd like afterwards as well, and you're welcome to have a chat with everyone. But this is not the end of the road. This is the first journey, the first stop in understanding this advisory opinion, what it entails and how historic it is. And I think everyone today, we thank you for your participation. We thank you for your support along the way, for coming along. And for those of you who have been with us on this journey for so many years, we want to thank you from the bottom of our hearts. A big vinaka from us all in the Pacific. And I think, as we say, this is a moment where we're trying to now move from systems of oppression towards systems of change that the ICJ has given us the tools to do. And we can't do that without mobilizing the power of the people. And to mobilize people, it's the first step is building knowledge and building and getting that information. And so this is hopefully contributing to a longer journey of getting to understand the transformational potential of this advisory opinion and how it can serve as the tool, the vehicle to demand greater accountability, ambition, fairness across the board. Someone said to me this morning, it's the dawn, it's a new dawn for climate justice. And I think that is the summary of what this advisory opinion is. And so with those words, I'd like to thank once again all our panelists, our high-level speakers for your wonderful remarks. Can we please give a big round of applause to all our panelists. And we thought a fitting close to this event would be a performance, a wonderful song, and we're very grateful to have Mia with us from the Pacific, who will be performing a song for us. So can we please give a big round of applause to Mia as she comes on stage.
Kole ke hufanga ngai talo whakatapu, ko osio na hawhaki, ka tā ke whaosia ki kau whakaosia polo kalama, ko lava e whiawhini. Malo lelei, good evening everyone. My name is Mia. I'm not a scientist, I'm not a lawyer, but I am a storyteller. And if yesterday affirmed anything for us, it's that the science matters, climate justice matters, and our stories matter. And when I was trying to decide what song to sing this evening, I was kind of going back and forth between two. And then the final question was said on intergenerational equity, and I thought, I know exactly what I'm going to sing. Because what really stood out for me when we talk about intergenerational equity, it reflects what our young people have been saying for as long as I've been in the climate space, which is over a decade. And it's that intergenerational conversations matter. And they're important and they are crucial in the discourse and the conversations. And so the song that I'll be sharing is called Generations. Oh. And I wrote this song as a promise to my younger sister, but I'd like to bring the song into the space as our promise to the generations that will come after us. And so thank you, PISFCC. You need to fix your acronym. It is so complicated. It is a complicated acronym to say. But thank you for hosting this event. I know that the conversations will continue. 90 minutes is never enough, but it's so important that we keep the momentum going because the generations after us depend on it. So, malo pito and ofatu. There's only so much that I could do, so I'll try my best to carry you. There's only so much that I could say, but I'll keep on trying anyway. Choosing to be silent just 'cause it's convenient still makes you complicit. So how can we fix this? How will I fix this? I know what I have to do to make sure you don't live what we went through. Brave this battle so you don't have to. 'Cause when I fight for me, I fight for you. I fight for you. There is so much we must unlearn. Generational curses at every turn. And if I wanna make sure we survive, gotta fight to keep the right things alive. Choosing to be silent just 'cause it's convenient still makes you complicit. So how will we fix this? How can we fix this? I know what I have to do to make sure you don't live what we went through. Brave this battle so you don't have to. 'Cause when I fight for me, I fight for choosing to be silent just 'cause it's convenient still makes us complicit. So how can we fix this? How will we fix this? 'Cause I know what we have to do to make sure you don't live what we went through. We've braved this battle so you don't have to. 'Cause when I'm fighting, we're fighting for you. We're fighting for you. 'Cause when we fight for us, we fight for you.
Thank you so much once again for joining us, everyone. We've got a reception at the back, so please help yourself to some refreshments and drinks. Thank you so much for coming. Have a wonderful night.